Howdy, my name is J.D. Foster, and I'm a civil litigation attorney in Ellis County, Texas. I would like to discuss the way that I approach civil litigation cases. Before I do that, I want to acknowledge that regardless of whether your civil litigation case involves breach of contract, a real property dispute, construction defect, breach of fiduciary duties in a trust or other relationship, or even any of the myriad of potential business disputes, we know these cases are among the most stressful types of litigation out there. We will work to minimize that stress and solve your problem with a common sense approach designed to maximize your outcomes. So what does that mean, a common sense approach? In my mind, that really takes two key considerations. The first, and perhaps the most important, is what is the return on investment associated with this lawsuit? No, I'm not purely talking about what the billable hour is going to be here. I'm actually talking about what is this case going to get you in return for what you're likely going to spend to get there? For instance, if we're suing over a contract valued at $10,000, and we're going to have to spend, because of the type of contract, the litigants at issue, or the complexity of the individual type of case that it is, we're going to wind up spending $15,000, then it wouldn't make sense to pursue that litigation. Although, again, we would also want to evaluate, for instance, whether or not we could reasonably expect to receive a refund of attorney's fees in this case, or some form of other additional cumulative damages on top of the pure actual damages that were suffered. Similarly, in an interrelated fashion, I consider every case from a strategic point of view. And I like to make the comparison between litigation in sports or litigation in a chessboard. You're trying to get to a particular place and have a particular result. And it is important that you not lose sight of your intended objective as the litigation goes on. In fact, I frequently have my clients write down from the outset of the litigation what their objectives are going to be in the litigation, so that we can constantly go back and compare what we're doing with those stated objectives and ensure that we're moving towards those objectives, not merely litigating a case. For instance, each motion should move you closer to your intended objective. Each discovery request should have some relationship to an item of proof necessary to prove your case, or for instance, to disprove your opponent's case. Similarly, some litigation isn't actually about money at all, or about the actual piece of property. I've encountered cases where the issue in the real property dispute that was involved actually turned out to have more to do with the ability to conduct business in a reliable fashion than it did with the actual piece of property. And so we were able to find solutions that actually were able to save everybody a lot of time, money, and heartache by thinking outside the box. And that's what I'm talking about when I say that we have to use a common sense approach when we tackle civil litigation cases. That isn't to say that we're not happy to go to court, file motions, and have jury trials. It's just to say that it's important that we keep in mind what the actual objectives are. And that's what we mean when we say that we use a common sense approach. It's my opinion that by using that same common sense approach, we actually minimize our clients' stress levels because they know that we're looking after what they're looking after and what's actually important to them. Simultaneously, our clients can trust us to use their money and our time in an efficient and an effective manner. With that in mind, I really encourage you, if you have any of these types of cases or any other type of case that I haven't mentioned that might fit into this category, to go ahead and contact our office at 972-937-1616, or to visit our website at elliscountylegal.com and get in contact with us to discuss your particular legal problem.